It is the middle of summer, and an 18-year-old has taken a job the way a lot of 18-year-olds do between school terms. Something physical, something temporary, something that pays for the next few months, and does not ask too many questions about the future. He's on a renovation crew working in the basement of a building in Belgium, and the task in front of him is about as unglamorous as construction work gets. Break through an old section of wall, clear the debris, move on to the next room. Nobody on that crew wakes up expecting the day to change their life. That is worth sitting with for a second, and because it is true of almost every discovery story like this one. The person holding the drill is not treasure hunting. They are not sweeping a field with a metal detector, dreaming about Roman coins. They are doing a job on a schedule for a wage in a basement that has probably been renovated, patched, and repainted more than once across its lifetime. And then the wall gives way wrong. Not the way old plaster usually gives way, crumbling into dust and chunks of stone. Something behind it catches the light. According to the one piece of reporting this story is built on, a report from ITV News, what the crew found behind that basement wall was gold. Bars of it, coins with it, hidden deliberately at some point by someone, inside a wall that had been doing a very good job of looking like every other wall in that basement. The estimated value being reported is around 9 million euros. Sit with that number for a moment, because it is the entire engine of everything that follows in this story. 9 million euros is not found money in the sense of a forgotten 20 in an old coat pocket. It is not even lottery money, because lottery money comes with a name attached and a legal process built for exactly that outcome. 9 million euros in gold, hidden inside a wall with no name on it, is a different kind of problem entirely. It is a fortune with no paperwork. And paperwork, it turns out, is the whole story. Because right now, as this video is being made, at least 3 different parties have a reasonable claim to some or all of that gold. And none of them have a clean, obvious, undisputed right to walk away with it. There is the 18-year-old who was physically holding the drill when the wall opened. There is the construction company that employed him and was contracted to do the work. And there is the organization that owns the building itself, which, according to reporting, is a charity. 3 parties, 1 pile of gold, and a legal question that most people have never had to think about until this exact moment. When you find something valuable that clearly belonged to somebody once, but that somebody is long gone and left no record, who actually gets to keep it? This is not a simple finders keepers situation, and it was never going to be the second the number 9 million entered the conversation. So before we get into what each of these 3 parties might actually be entitled to, and before we get into what a charity might even do with a sum like this, if it is awarded, we need to slow down and look at how the law generally treats a find like this one. Not because we know exactly how Belgian courts will rule here, we do not, this case has not been resolved, but because understanding the general shape of the law is the only way to understand why this is genuinely difficult and why it might take a long time to settle. 1 basement, 1 wall, 1 teenager who is just trying to get through a Tuesday. And now, a legal question old enough that entire branches of property law exist just to answer it. Now let's talk about how treasure like this is generally handled, legally speaking, across continental Europe, with a clear flag up front. This next section is general legal context. It is not a description of a confirmed ruling in this specific Belgian case, because as of this reporting, there has been no public resolution. What follows is how these situations tend to work and how the questions tend to get asked wherever in Europe they come up. The starting point in most European legal traditions is a concept sometimes called treasure trove, though the exact modern terminology and rules vary significantly from country to country and have been reformed over time almost everywhere. The old idea behind treasure trove law was simple. If you find valuable objects, usually gold, silver, or coins, that were hidden long ago by an owner who cannot be identified or found, the state often has an interest in that discovery. In many countries historically, that meant the crown or the state, could claim the find outright on the theory that anything with no living owner defaults upward eventually to the sovereign authority. That is sometimes called in various legal systems a form of bona vacantia, ownerless goods reverting to the state. But most modern European countries have moved away from a pure all or nothing state claim. Contemporary treasure and finders laws generally try to balance three separate interests at once, and this is the part that matters most for understanding why this Belgian case is genuinely a three-way question rather than an obvious one. First, the landowner's interest. In many legal systems, someone who owns land or a building has some claim to what is found on or in that property, on the reasoning that whatever is buried within your walls or your soil is, in some sense, already within your legal sphere of control, even if you did not know it was there. Second, the finder's interest. Many countries recognize that the person who physically locates and unearths the find has done something that deserves legal weight, effort, discovery, sometimes even risk. Finders' rights vary enormously by country, from a meaningful percentage of value to a fixed reward, to, in some jurisdictions, comparatively little at all if the finder was an employee acting within the scope of their job at the time of discovery. That last detail matters enormously here because the teenager in this story was working, on the clock, for a construction company at the moment he made the find, and that employment relationship is exactly the kind of fact that can shift a case in ways the public does not always anticipate. Third, the state's interest, particularly where an item has cultural, historical, or numismatic significance. Older coins or gold with archaeological value can trigger a completely separate layer of law focused on cultural heritage protection, sometimes overriding both the landowner and the finder's claims entirely, with compensation, if any, set by a government valuation rather than open market price. Now layer in the charity. The building where this gold was found is reportedly owned by a charitable organization, and that detail complicates an already complicated picture because charity-owned property often carries its own legal obligations. Charitable organizations are frequently required, under charity law in the country where they are registered, to act in the best financial interest of the charity's stated purpose, meaning that if the charity does have a legitimate legal claim to a find made on or in its property, its trustees or governing board may be under a formal, sometimes legally enforceable duty to actually pursue that claim rather than simply letting the finder or the construction company walk away with it. In other words, even if the individuals involved with the charity personally feel generous or sympathetic toward the teenager, the charity as an institution may not have complete freedom to simply decline the money. There's also the question of time. Many European property and treasure statutes include waiting periods and public notice requirements before any fine can be legally awarded to anyone, specifically to allow a real historical owner or their descendants to come forward and prove a claim, however unlikely that may be for a discovery like this one. That waiting period, wherever it applies, and however long it runs in this specific jurisdiction, is itself a source of the story's tension because it means that even once the legal framework is properly applied, nobody gets a fast answer. The gold can sit functionally frozen in evidence or in secure holding for a meaningful stretch of time before anyone can spend a euro of it. To be direct about the limits of what we actually know here, we do not have confirmed details of Belgium's specific current treasure-trove statute as applied to this exact case. We do not have a confirmed ruling, and we do not have confirmed percentages or allocations promised to any of the three parties. What we do have is the general shape of how these disputes tend to unfold across similar legal systems and a live, undecided example playing out in real time behind one basement wall in Belgium. Step back from the statutes for a moment because underneath all of that legal architecture are three very human positions, each of them completely understandable on its own terms. Start with the teenager, 18 years old, on what was almost certainly meant to be an unremarkable summer job, the kind of work that builds a small amount of savings and not much of a story. Instead, he is now, at least in a moral, if not yet legal sense, at the center of a €9 million question. It is worth imagining, honestly, what that moment must have felt like the second the wall opened and gold caught the light instead of dust and old brick. Not triumph exactly, more likely a strange, disorienting mixture of excitement and immediate uncertainty, because anyone with a passing awareness of how these stories usually go knows that finding something valuable and legally owning something valuable are two very different events, separated by months or years of process. Reporting on this story has not included extensive detailed statements attributed to him, which is itself worth noting rather than filling in with invented reaction or imagined dialogue. What we can say is that his position as the finder and as an employee sits at the center of exactly the kind of finder's rights question described a moment ago, and that his outcome depends heavily on details of Belgian employment and property law that go well beyond what a single news report can capture. Then there is the construction company. Employers in situations like this occupy an interesting middle position, legally and reputationally. On one hand, the company was contracted to do work on the property, and depending on how Belgian law treats discoveries made by an employee during paid working hours, the company itself may have a formal legal interest in the find, separate from whatever the teenager personally believes he deserves. On the other hand, publicly disputing a young employee's claim to a life-changing discovery is not exactly a comfortable position for a company to be in. Reputationally, in the court of public opinion, even if its legal footing is genuinely strong. Companies in these situations often have to weigh a technically defensible legal claim against the much messier question of how that claim will look to the public, to future employees, and to anyone watching this story online, which, at this point, is a great many people. And then the charity, the actual owner of the building where all of this was hidden. This is arguably the most interesting party in the entire dispute, because a charity's motivations are structurally different from either an individual's or a for-profit company's. If the charity has a legitimate legal claim to some or all of the gold, that claim is not really about personal enrichment, it is about mission funding. Depending on what the charity does, 9 million euros or any meaningful fraction of it could represent an enormous, possibly transformative injection of funding toward whatever cause the organization exists to serve. That is worth remembering before rushing to cast the charity as some faceless institution trying to take money from a deserving teenager. If it does pursue and win a claim, it is very plausibly doing so because its governing obligations essentially require it to, on behalf of whatever community or cause depends on its funding. None of this makes any single one of these three parties the clear villain or the clear hero of the story, and that is precisely why it holds attention the way it does. There's no easy answer here. There's a teenager who did the actual physical work of discovery. There is a company that employed him and may hold contractual or legal standing of its own. There's a charity whose entire operating mission could shift meaningfully depending on how this resolves. All three positions are legitimate. All three could, under different legal readings, walk away with a real claim. And as of now, none of them has a final answer. Stories like this one tend to go viral for a reason, and it is worth naming that reason directly rather than pretending this is some isolated, freakish event. Construction and renovation crews stumbling onto hidden fortunes is a recurring, genuine pattern across recent years, not a manufactured internet myth. Workers pulling up floorboards and finding coin hoards, demolition teams discovering hidden safes behind false walls, homeowners renovating basements or attics and uncovering caches that nobody living had any memory of. Each case is different in its details, its country, its legal outcome, but the pattern itself, ordinary labor accidentally intersecting with someone else's long-buried fortune, is one of the most reliably fascinating stories in the world, precisely because it could, theoretically, happen to absolutely anyone holding a drill or a crowbar on any given Tuesday. Part of the pull is mathematical. The odds of it happening to you personally are vanishingly small, but the fact that it has verifiably happened to other completely ordinary people means the possibility is never fully closed off. And that keeps a kind of low hum of curiosity alive in a lot of us. Part of the pull is also, frankly, the tension between wanting to believe finding something like this should mean an easy, happy ending, and the reality that it almost never resolves quickly or cleanly, that instead it drags the discoverer into exactly the kind of tangled ownership question this Belgian case is now sitting inside. It is worth being careful here not to claim direct one-to-one parallels between this case and any specific past example, because every jurisdiction handles treasure and finder's law differently, and the details that decide one country's cases often do not transfer cleanly to another's. What can be said, safely and honestly, is that this general category of story, hidden fortune, ordinary discoverer, competing legal claims has repeated often enough across different countries and different decades that audiences have developed something like an instinct for how complicated the aftermath usually gets, even when the discovery itself makes for a 30-second viral clip. That is really the tension sitting underneath this entire Belgian story right now. The discovery took, at most, a few dramatic seconds. The resolution, whatever it eventually turns out to be, could take months, more likely longer, moving through legal channels, valuations, competing claims, and whatever waiting periods Belgian law requires before anyone can be declared the rightful owner of gold that nobody alive can prove they buried. So where does that leave us right now with the information actually available? It leaves us with an unresolved story, and that is not a disappointing place to end. It is the honest place to end, because pretending otherwise would mean inventing a court ruling that has not happened, or a settlement that has not been reported, or a final number that nobody has confirmed. What we know reliably is this. A renovation job in Belgium during the summer led an 18-year-old worker to break through a basement wall and discover gold bars and coins. The estimated value being reported sits around 9 million euros. The property is reportedly tied to a charitable organization, and as of now, there is no confirmed final legal outcome deciding who actually owns that gold. Everything else, the exact statute that will govern the ruling, the specific percentage any party might receive, the precise weight or count of what was found, remains genuinely unconfirmed. And this video has tried, deliberately, not to fill those gaps with invented specifics dressed up as fact. What we can offer instead is the general shape of the law that will likely apply, the honest complexity of three legitimate competing interests, and the recognition that this is exactly the kind of case that could sit and process for a long stretch of time before anyone gets a definitive answer, which leaves the actual, open, unresolved questions, the ones worth sitting with rather than rushing past. Who do you think morally deserves that gold? The teenager who found it while working, the company that employed him, or the charity that owns the walls it was hidden inside? Is moral deserving even the same question as legal entitlement? Or are those two completely separate conversations that just happen to be tangled together here? And if you were 18 years old, holding that drill, and the wall opened onto 9 million euros with no name attached to it, what would you actually do in that first disorienting minute before any lawyer, any headline, any charity board meeting ever entered the picture? This story's not finished. It is, right now, still sitting inside exactly the kind of legal waiting period described earlier, the kind designed to let claims surface, valuations settle, and rightful ownership, whatever that ends up meaning here, get sorted out properly rather than quickly. When that resolution comes, whenever it comes, it is worth knowing. So if this kind of story, the real ones, the unresolved ones, the ones where ordinary people collide with genuinely strange fortunes, is the kind of thing you want to keep following. Subscribing means you will see the follow-up the moment there is an actual answer to report rather than a guess.